So now option two, parties don't agree, something's changed, you want to modify. Michael, what is that person's option? What do they have to do if they want to try to modify the custody order?
They have to go to court and they have to file a motion to get in front of a judge in court. And how that looks is your motion is basically your, what in the legal profession we call the prima facie case. This is the facts I'm putting forth. And I know we're going to get into the legal standards and whatnot later and how the court actually looks at this. But procedurally, you put your motion together and you put everything in there that has occurred generally since the last custodial order, with some small exceptions to that. And you make your arguments to the court as far as why custody should be modified. And then the court sets a hearing. In the South, this is how this works. They set a hearing, and it's what I call a gatekeeper hearing, or what we call a Rooney hearing, which is a initial hearing where the judge says, okay, if I take everything you say as true or mostly true, is there enough here to modify custody? And then if there is, the court can go ahead and set proceedings to modify custody. So the court can't modify custody without further due process than what's been established at that point. But they can deny the motion outright if they say, hey, you haven't made adequate cause, is what the Rooney standard refers to it as, where basically you don't have enough here, that even if this is all true, I give you every benefit of the doubt, there's just not enough here. They could deny you, but if they want to entertain the motion, set further proceedings where they can take some evidence and then determine then at that time if the final custody order we referred to before needs to be modified.
And we have the same local rule up here in the North where there has to be kind of that gatekeeper hearing first, and then the court decides whether or not to have an evidentiary hearing or if there's not enough there.